There is a specific proceedings described in Polish law that a court, a custody court, decides whether to give a permission to a minor to terminate her pregnancy. And it is likely, although I haven't heard of anyone trying this in practice yet, that the court might possibly allow someone acting as an attorney of the unborn child, a curator ventris, to intervene in these proceedings on the child's behalf. The other possibility is intervention of the public prosecutor who has this right. And therefore, please, let me make a closing argument in a case like this. I'll help myself with the papers because I haven't made a closing argument in English so far. Honorable Court, then, after all that has been said throughout the proceedings, what has been said by the social service officer, by the physicians, by the applicant herself, it might be very difficult to grasp the issue which you're about to decide. Statute-wise, you are about to give or not your permission to the minor woman to terminate her pregnancy. Taking this decision includes examination whether there has been met the statutory conditions set forth by the Article 4A of the Act on Family Planning, the Protection of the Human Fetus, and the conditions permitting termination of pregnancy. These are that the abortion can be carried out only until such time as the fetus is capable of surviving outside of mother's body, that the prenatal tests or other medical findings indicate a high risk that the fetus will be severely or irreversibly damaged or suffering from an incurable, life-threatening disease. From the language of the next lines, it shows that checking all these conditions, the satisfaction of these conditions is not enough to solve the case. The court shall still have the last word. In other words, in other case, the court's permission would be useless. Yet the article reads in section 4 that when the woman is a minor under the age of 13 or older, but there is no consent granted by her legal representatives, parents in most cases, the court hears the opinion of the woman and takes the decision on permitting the abortion. So, what is the decision based upon? Are there any solid grounds, any objective grounds on which the court may rest? And I believe there are. Law is all about values. It's all about values. This is because regulations refer to the real world. And in the real world, they protect some goods directly, others indirectly, overlook other goods and sacrifice some of them for the sake of those which are given priority. And the cited abortion law reflects a very particular view on the hierarchy of values too. And following this particular view, it says which behaviors are legally permitted and which aren't. Therefore, the court must examine this hierarchy of values, and it cannot refrain from confronting it with the axiology, the system of values laid down in the Constitution. Yet, there is an obligation on the court to apply laws in accordance with the Constitution. And further to that, you cannot refrain from confronting these values with the real world, with the goods that are to be sacrificed and protected in the real life through your decision. These are the objective grounds for the court's decision in this case. There is a certain scope of discretion, and it lays just here in making the ruling coherent with the Constitution and with the real life. First of all, this language is challenging. For example, what medical findings should be allowed as evidence here in this case? What medical findings? In what way must these findings indicate a high risk that the fetus will be born with a congenital disorder? Directly or indirectly? Is it enough to examine the genotypes of parents and their ancestors to determine that the child will be in a high risk, born with defects? Is it enough? And if what does it mean that the disease is incurable in this article. If the child develops as he grows and he gets better from a life-threatening to a lighter disease, will such a disease still be considered incurable? Later on, what's the measure of high risk in this article? What is the measure of severity here? And what does it mean that the child is able to survive outside of mother's body? It's very tough to determine this. I've heard of cases in Poland where in the same hospital ward, in one room, babies with Down syndrome are rescued with cutting-edge medical equipment, whereas in another room, similar babies of the same age are delivered after induction and then left to die, although it sometimes takes hours. And are those babies capable of surviving outside of mother's body? I shall leave the answers of these questions to the court. This regulation is concentrated on the state of illness. It can be seen at first glance. It even names two kinds of illnesses. First, a severe, irreversible damage, and then an incurable, life-threatening disease. The medical examinations referred to in this article are targeted at determining whether there is a risk of such a disease. The illness is the central point. And for this reason, it might be puzzling why isn't it precisely described or named with medical terms. Instead, it's described in a colloquial speech, such as the fetus will be severely and irreversibly damaged or suffering from an incurable, life-threatening disease. Why is it so? Please look at the number of strong emotional notions describing the fate of the child. High risk. The fetus will be severely damaged, irreversibly damaged, suffering from an incurable disease, suffering from a life-threatening disease. This is an emotional text, and the emotion underlying it is fear. And it's just to ask of what is this fear? And for two reasons, it's not the fear of the child itself. First, because the illness is not described precisely enough to be cured. And second, because the solution to the problem is not the treatment, but elimination. One has to realize the fact that this is an emotional text. And look at it, at the state of affairs. The court has to rule now without fear, to remain realistic. There is a proverb in Slavic languages saying that fear has big eyes. In Polish, strach ma wielkie oczy. The fearful man ascribes too much of negative value to the object of fear, and he focuses so strongly on it that all the other surrounding reality loses its value to him. This law mentions such actors as the child, his mother, her legal representatives, and different physicians. They carry out examinations, come up with some findings, try to estimate the risk of illness, and finally terminate the pregnancy. The mother is also active. She subjects herself to these examinations, asks for abortion, and undergoes it. The child, it might seem passive, but it is not. It tacitly develops, and when he will be able to survive outside of mother's body, he will no longer be able to a lawful elimination. So my little client is running for his life. Look at other interrelations between the actors and their acts. In this article, the child's vitality, which can save him life, is measured by the same physicians who are to about determine his illness, the premise of eliminating him. However, there's also such an interrelation that if the woman doesn't want the pregnancy to be terminated, the child will live, irrespective of the fact that he might or she might be ill. And she's under the pressure of time. The diagnosis takes time, especially a thorough one. And the child develops and gains the ability to survive outside of her womb. She has to make the decision under this pressure. And finally, the court decides whether the determination is accessible, whether it is admissible. And the whole legal structure in this article is consequently structured to enable this decision. Opinion of the mother, decision of her parents, opinions and findings of the physicians, the time frame, these are just factors, factors in the decision-making process. And the decision is about two options. The first option, law admits the termination, and in effect the child can be killed because of the risk that he or she might be ill. If he were healthy, he couldn't be killed. And the second option, it results with different chances. The woman who will be carrying and possibly delivering the baby has the chance to grow up to be a mother. The child has the chance to live and develop and be taken care of. But the court doesn't change the reality. You do not change the natural cycles. The child might develop or might die. He or she may become healthy or ill. The mother might grow up and love the child or leave the child in the hospital. What the court actually decides is whether law agrees with the attempt of killing this particular unborn child because of the risk that he or she might be ill. And in the real world, outside this courtroom, health and illness, development and passing, these are all aspects of life. They are nothing but ways in which the life shows itself. There is no constant feature in it. There is no constant feature in life besides the constant change. And life, including its full range of manifestations, is protected legal value. It is protected because it's the most fundamental one, without which no other can be satisfied, no other can be made possible. And the right to life is commonly recognized as a natural one, stemming from an inviolable human dignity. Our Article 38 reads, "The Republic of Poland shall ensure the legal protection of the life of every human being." And according to a settled construction by the Constitutional Tribunal, this provision covers the life from the moment of conception because there is no objective criteria to differentiate between the values of life in different phases of its development. All the doubts must be resolved in favor of the human life, in dubio pro vita humana. And in the real life, impaired people evoke contradictory reactions of others, such as anger or help, fear or help, or compassion. And these reactions depend on the greatness of one's heart, on the ability to act for others. Reactions to encountering people suffering from diseases that do not change their looks outside aren't so extreme. They usually include some amount of compassion, and they vary from asking what would be good for the ill person to deciding what is in his best interest. Let us realize that by using the premise of the risk of illness to kill one's baby, one gains nothing besides the ease of the fear that he might have an ill baby. At the moment of taking this decision, there is no real burden yet, just the fear. Of course, this burden can come true, including life travails, maybe dwelling in hospitals for years, people laughing, people pitying, but no one knows what will the burden really be, and no one knows whether it will come true, and no one knows for how long the child will live. And it's good to see that those who had the chance of holding their lethally ill baby for a moment after birth, just to let it die soon afterwards, they do not regret. Those who take care of such children, lethally ill children, they do not raise claims for eliminating them. This project, this plan is only possible as long as one's mind is affected by the fear. Everything becomes different when one gets into the real life. The very premise of law, to discuss on it for a moment, the law's reaction to illness and suffering in this article is evidently eugenic. As Madison Grant, an American advocate of eugenics, put it in 1921, a rigid system of selection through the elimination of those who are weak or unfit, in other words, social failures, would solve the whole question and get rid of the undesirables who crowd our jails, hospitals, and insane asylums. The state, through sterilization, must see to it that his line stops with him. This is a practical, merciful, and inevitable solution of the whole problem that can be applied to an ever-widening circle of social discards, beginning always with the criminal, the diseased, and the insane, and extending gradually to types which may be called weaklings rather than defectives, and perhaps ultimately to worthless race types, which in that context, of course, included Poles, Russians, and other comers from the Central and Eastern Europe after the First World War. Or citing Michael Geyer from 1927, let us but extend our vision from immediate suffering to prospective suffering of the countless unborn descendants of our present unfit, and ask ourselves the question, why should they be born? The rhetoric behind the eugenics is such: suffering is most evil, therefore it should be eliminated, and therefore it would be the best for the suffering people not to exist. And one of the many reasons why this argument is false and unacceptable is that it is formed by the healthy in the name of the ill. This is a different situation than when someone suffering asks himself to be killed, although answering such a plea remains a manslaughter. In the 9th circle of Inferno, according to Dante, there strive the Count Ugolino della Gerardesca and his sons. They are starving to death in a tower. The sons ask their father to eat them and end their suffering. Father, our pain, they said, will lessen if you eat us. You are the one who clothed us with this wretched flesh. We plead for you to be the one who strips it away. But no one, whether he asked for it or silently suffered termination, is thus protected from suffering. It is impossible, logically impossible, to stop to exist but still had features. Look at the absurdity of the concept of someone not living, but well-being. Yet, the eugenicists still justify eugenics as a protection, not a punishment. So let us ask again, who is thus protected? The society, those who will survive, those fit who will survive. By getting rid of the weak individuals, the social organism is supposed to become healthy. Ugolino can help us again grasp the essence of this mad idea, but we must not forget that he speaks from hell. And I, already going blind, groped over my brood, calling to them, though I had watched them die for 2 long days, and then the hunger had more power than even sorrow over me. The hunger, that it will not be enough for us. The hunger. Our law would not justify Ugolino for devouring his sons, neither based on the argument that he stopped their suffering, nor because he enabled their expressed desire that he feasts on them so that he might save himself. And this line comes from Piero Tozzi, for which I'm grateful. Normally, parenthood is something different. Normally, it consists in resignation from the parents' well-being for the well-being of their children. And normally, this huge effort is supported by the community. The fact that life inevitably includes illness, weakness, and dying is true for an individual as well as for the society. Based on this recognition and the principal rule of solidarity, our Constitution affirms the rights to special health and material care for children, pregnant women, impaired persons, and the elderly. to families, especially those with many children or those parted, and to the children themselves, and to mothers in the period before and after giving birth to a child, in the articles cited in the paper, which you may look at. And by what logic are these norms connected with the rule that if the child might be born with a congenital disorder or suffer from a life-threatening disease, it might be killed because it doesn't deserve such an amount of legal protection as the healthy one? By no logic at all. And there are no freedoms, no such rights, and no such values in the Constitution that would justify an exception from the protection of life in this case. Further to that, this rule is too vague, as I've mentioned at the beginning, to even apply. The court and the physicians, the experts, would have to pretend that they know what this wording really means, and where are the limits between the applicable and the inapplicable in this case, and similar cases. When the Constitutional Tribunal was overturning the previous abortion law that enabled abortion on the grounds that the mother is in a severe personal or economical situation, he set forth a constitutionality test. First, whether the constitutional value, right or freedom sufficiently justifies the premise of termination in the given circumstance, and second, whether criteria of the legalization of abortion are clear and precise enough not to violate the constitutional guarantees of human life protection. And the eugenic-based abortion, which we are talking about now, is neither sufficiently justified nor precise enough to pass the constitutionality test. And the conclusion must be that the court must refrain from applying this law in this case based on the Article 8 of the Constitution. Honorable Court, please take all the necessary time to weigh all the arguments which you were presented with, and take the clear insight into the reality in which you rule. Please contemplate upon the values which are here at stake. You certainly have enough time not to hurry, given the time frame for abortion under this premise. And there are good reasons to take this time. The child develops and the diagnosis might change. It is established that the most worthy and infallible results can be taken only between the 18th and the 22nd week of pregnancy. Some severe malformations, which are believed to fall under the premise of this discussed rule, can be successfully treated if a reference center is timely consulted. And what is most important in such a case, the mother's mind can change as well. Thank you.